Hi and welcome back. So today we are going to talk about confessions, what they are in the law of evidence and in the Evidence Act of Kenya. We'll also talk about confessions by words and confessions by conduct. We'll look at the difference between them. We'll look at instances where the accused person remains silent. What happens to him, okay, when he remains silent against accusations that are made. We'll also look at the failure to reply to written allegations, okay, and whether that will amount to confession. We'll look at vicarious confessions, just like in the last video we looked at vicarious admissions. Here also we look at vicarious confessions, and we will see whether or not these confessions made by other people on behalf on what they have had somebody confess are admissible. Okay, we'll look at the evidence out of court confession rules of 2009. These are rules that regulate how confessions are made, how they are received by and who receives them, who has the right to receive, which officer has the right to receive confessions from suspects or accused persons, and what are they supposed to do, what conditions are they supposed to ensure when they are receiving those confessions. Okay, we'll also look at confessions to third parties. Okay, we'll also look at voluntariness. Okay, so this, I think, is the whole idea that confessions have to be made voluntarily. They can't be induced out of the accused person's mouth, or they can't be forced. Okay, or yeah, the confession must be received or given voluntarily. Then we look at the situations where confessions are induced. So we look at inducement, where also they are threatened out of the accused. We look at the threat aspects. We look at persons in authority. Okay. We will look at the principle of confirmation of facts. Okay. Okay, we'll look at repudiated and retracted confessions. When did we talk about this? Repudiated and retracted. It's very similar. In a previous video, we talked about what were they called, which subtopic was this, where we differentiated the meaning of repudiated from retracted, and we said repudiated means it means withdrawn, to take back. Yeah, retract means to cancel, if I'm not wrong, but I can't remember which exactly subtopic was that. Let me just go back a little and see. I really like to connect these dots because it doesn't make sense to just read on and not remember or make the necessary connections with what we have done in the past. I don't know what it was. It wasn't hearsay. So let's see what it was that we talked about, repudiated and retracted. Yes, it was under corroboration. Okay, so when we discussed corroboration, we differentiated the terms repudiated and retracted confessions, where we said a retracted confession occurs when the accused person, okay, admits that he made the statement recorded but now seeks to recant or take it back, whereas a repudiated statement is one which the accused person avers he never made. Yeah, so I think I got it mixed up. So that was where we talked about where corroboration was required as a matter of practice in the identification by a single witness. Yeah, so we talked about that. Where we said where confessions were repudiated or retracted, some corroboration was required to admit any statement in the confession as evidence. Okay. All right. So it's good to know that there are always connections. So here also in confessions, today we'll talk about repudiated and retracted confessions. Okay, and we'll talk about Vadire. I don't know how it's pronounced. That is trial within a trial. We'll talk about the procedure of that. We'll also look at confession of an accomplice. Okay. And remember in the video we did about corroboration, we said where an accomplice gives evidence, that evidence needs to be corroborated because it is it is the belief that an accomplice is likely to not tell the truth, and they are likely to just give that evidence in return for something else, maybe leniency or mitigation of his sentence. So we'll finish with that, the confession of an accomplice. Now let's start. All right, introduction. What is a confession? So under section 25 of the Evidence Act, confession is defined to mean words or conduct or a combination of words and conduct from which, whether taken alone or in conjunction with other facts which have been proved, an inference can be reasonably be drawn that the person making it has committed an offense. So it's all about making the court come to the conclusion that a person has committed an offense, okay, right, from his words or from his conduct. So the words or conduct giving rise to confession may stand alone or may be conjoined with other facts. A statement made by a person, though not amounting to a confession, may become one if, when taken together with other evidence, reasonably lead to an inference that the maker has committed an offense. Now, let me take you back to to the last video we made about admissions, where we looked at what admissions were. And when we were differentiating between admissions and confessions, we said that admissions were like the formula that gets you to the confession, which is the solution. So it's like a confession is the destination, and admissions are like those key scattered facts, which when combined together or which by itself will lead to that. So it's okay. Admissions are a process. Confession is the the thing itself. Okay, is the result. Okay, so here we see that confessions are words or conduct that give rise to an inference, okay, that someone has committed a crime, and these words or conduct can act alone and they will suffice as confession, or they will be mixed in with other facts or joined together with other facts which have been proved. So I would like to think, or I'm getting the belief that those other facts, okay, along the road are what admissions will be, okay. So we move on. All right, so we have a case of Tuamoy versus Uganda, where judges of the East African Court of Appeal summarized the position of the law on confessions. They said this: we would attempt to simplify the position. First, the onus of proof in any criminal case is on the prosecution to establish the guilt of an accused person. We said this in the video about burden of proof, where we said in criminal matters or proceedings, the burden of proving beyond a reasonable doubt that the accused committed the crime falls on the prosecution. So the prosecution from the beginning to the end of the criminal trial has to discharge this burden, okay, which is this in the same words means honors. So honors and burden of proof are the same thing. So let's move on. A conviction can be founded on a confession of guilt by an accused person, okay. The prosecution must first prove that this confession has been properly and legally made. So just a point here before we move on. When we discussed confessions in the last video I made yesterday, we talked about the fact that the prosecution has to first, in a criminal trial, has to first uh, prove that the statement was an admission of fact or of law, and it was made voluntarily, it was an acknowledgement of fact, it was clear and precise. So the burden of proving will fall on the prosecution first to establish that a statement is indeed uh, an admission. It has qualified to become an admission and is clear and concise and certain and all those things. And once it does that, then the burden shifts to the accused either to defend or challenge the admission. Okay. Here with uh, here we see also in confessions that the prosecution also needs to first to prove that this confession has been properly and legally made. So that is a big thing, okay? The confession has to be properly made, like we mentioned. It's the same thing basically. It has to qualify as a confession, also has to make to have been received by the right officer of the right rank, and to have been received in accordance with the conditions which we'll discuss of in the rules, confession rules of 2009. So that will be like being received voluntarily, making sure if it's a minor, the guardian is present, things like that. So moving on. So the main essential for the validity of a confession is that it is voluntary. So like I said, but the other legal requirements of each territory must also be established. Thus, in Uganda, if the confession is made to a police officer, then it must have been made to an officer of the rank of corporal, corporal or upwards, and also in accordance with the evidence statement to police officers' rules. So every country has its own rules on how to receive confessions, which officer of which rank receives, and everything, and in what conditions. All right, that confession is to be received. In Kenya, I told you we have the confession rules of 2009. These ones will outline everything, and we're going to look at them. So just hold on a little bit. If the court is satisfied that the statement is properly admissible and so admits it, then when the court is arriving at its judgment, it will consider all the evidence before it and all the circumstances of the case. And in doing so, will consider the weight to be placed on any confession that has been admitted. In assessing a confession, the main consideration at this stage will be, is it true? All right, and if the confession is the only evidence against an accused, then the court must decide whether the accused has correctly related what happened and whether the statement establishes his guilt with that degree of certainty required in a criminal case. Okay. This, which is beyond a reasonable doubt, okay, this applies to all confessions, whether they have been retracted or repudiated or admitted, okay. But when an accused person denies or retracts his statement at the trial, then this is a part of the circumstances of the case which the court must consider in deciding whether the confession is true. So that was the what do you call the obiter dicta, okay, of the case of Tuamoy versus Uganda, where the judges explained in detail what is a confession and exactly in Uganda which officer is supposed to receive, and generally how confessions are supposed to be uh, are received. Okay, they have to be voluntary and have to meet all those other requirements. Now in Xiaomi versus the emperor, this is another case. The principle was confirmed that a confession must either admit in terms the offense or all facts which constitute the offense, and intended to free the maker from blame for the act admitted in the confession. So we see that in this case it was confirmed that a confession must admit the offense, okay, or all facts in totality which constitute the offense, okay. All right. And also it must be intended to free the maker from blame for the act committed in the confession. The same decision was upheld by the court in Uganda versus Xiaomi Mutahanzo, where it was held that a confession connotes an unequivocal admission of having committed an act in law that amounts to a crime, and must either admit in terms the offense or at any rate substantially all the facts which constitute the offense. So now we see all these elements that qualify a statement to be a confession. It must admit, okay, that statement must admit uh, the offense, okay, that indeed I committed that offense, okay, or it must admit all the facts which make up the offense, okay. All right, and also it must be, yeah, it must be unequivocal, okay. It must be unequivocal, okay. That means, just a minute. It must be clear, okay? It must not be ambiguous. So that is what it means. It must be very clear and should not confuse in any way. Now, in the case of Uganda versus Lacote, that was a 1986 case, it was held that the confession was equivocal since the accused admitted to having assaulted the complainant but went ahead to explain why he did so. So the statement made must admit to committing the offense or to all the facts leading to the offense. Uh, okay, to all the facts which constitute the offense, and those statements must be uh, clear and not ambiguous. They must be clear and straight to the point. Like in the case where somebody says, yes, I assaulted so and so, but went ahead now to explain why he did so, it would be termed as ambiguous. Okay, so we move on. Confessions by conduct. What would give rise to confessions by conduct? Actions of a party which tend to show a consciousness of guilt or liability or a desire to conceal wrongdoing may be deemed to amount to a confession. So examples include using bribery, so bribing somebody, intimidation, or other forms of undue pressure to influence the testimony of a witness or to prevent a witness from testifying, fabrication or destruction of evidence, and flight from custody. It has also been held that violent and abusive behavior of an accused when arrested was capable of constituting an admission of violent and abusive behavior in a public house. What is this? I think there is a confusion here. So we see that we say confessions are either by conduct or by words. So by words have to be admitting the offense, so the conditions admitting to the offense or to all the facts which constitute the offense. They have to also be intended to remove blame for the act committed by the accused. They also have to be clear and straight to the point. Okay, those are the conditions for confessions by words. Confessions by conduct, we have been given examples, such as, for example, when the accused is hostile. Okay, upon arrest, they try to run or hurt the police officers in any way. That can amount to a confession by conduct. Okay, why would an innocent person run? That's the whole thing. So the next thing is bribery. Okay, when you bribe a judge, for example, and it's you're caught doing it, or you bribe the court registry, so you want to make some evidence, what you want to make some files or pleadings of the opposite party disappear. When you do all those backdoor stuff. If you Okay, another is intimidation or other forms of undue pressure to influence the testimony of a witness. So where you know who is testifying against you, and you go ahead and try to to either chase them around or stalk them, or try to threaten them, you know so that they can change their testimony, or maybe bribe them also. All right, or you kidnap the witness and they cannot show up to testify in court. All those actions are seen as amount to confessions on the part of the accused or suspect. So fabrication or destruction of evidence, where you make evidence disappear. You find a way to make evidence in the in the evidence. It was if it's in the lab or something, I don't know where they keep them, the evidence lockers. You make it disappear, okay, so that it can't be produced in court. Or where you run from custody, okay, where you escape from not prison, where you escape, where you are being held as you pending the hearing of your case, okay, that could be taken as a confession. It's okay. And violent, abusive behavior of the accused person when you are arrested. That's why you should not resist arrest. When you are arrested, you simply just listen to what the police officer is saying and don't resist. Don't resist arrest or run or hurt the police officer. You are just making matters worse. Now, moving on, failure to reply to an accusation. What should a court make of an accused decision to remain silent in the face of accusations against him? So, in the situation where an accused person is read their charges, for example, in the court, their counts, count one, robbery with violence, count two, assault, count three, breaking and entering, count this, and then the person is just silent. What do you do? What should a court make of an accused decision to remain silent? The rule is that an accusation is not evidence against an accused unless and until he admits what has been alleged against him. So the fact that an accused fails to reply to an accusation in his presence is not normally evidence against him. An accused is entitled to his right of silence. So an accused can remain silent. I think this is under Article 50 of the Constitution. Let me just check. Mm, yeah, so that is under Article 50, 1J, 1I of the Constitution, to remain silent and not to testify during the proceedings. So an accused person has the right to remain silent under Article 50, 1I of the Constitution of Kenya, 2010. They can remain silent and refuse to testify. All right. So exceptions do, however, arise so that a court may draw inferences from an accused silence under question, though this does not abolish the rule above. So where circumstances are such that a reply or a denial of what has been said or asked would have been expected, failure to reply is tantamount to an acceptance of an allegation. This principle found expression where an accused was charged with the murder of a young woman by stabbing her. So we are given here an example of a case scenario. No, it's an actual case, I think. So where a man was charged with the murder of a young woman whom he stabbed. Okay, whom he stabbed to death. Her mother found her bleeding from the wounds and saw the accused in the compound holding a knife. Her mother accused the accused twice of stabbing her daughter, and he did not bother to reply. Next, she grabbed the accused, told him she would keep him there until the arrival of police. He then attacked her with the knife, chopping her finger. The Privy Council upheld the judge's decision that the accused's reaction, including his silence, be taken into account in deciding whether he was guilty or not. That was the case of Mitchell, 1892. Okay. So we see in the case of Mitchell of 1892, the court considered silence by the accused, okay, to be a confession of guilt. All right. So that was like an exceptional circumstance, but normally the accused person has a right to remain silent. That is generally the rule. Has a right to remain silent and refuse to testify. He can just decide to keep quiet from beginning to end. Can he refuse to take plea? Wow, I really don't know. So, failure to reply to written allegations. In a limited number of cases, failure to reply to allegations contained in correspondence may amount to a confession. A case in point would be the matter of a letter that imperatively demands an answer to an allegation contained therein. So that failure to answer would give rise to a confession. That was in the case of Wiedemann versus Walpole, 1881, where the court held that failure to answer letters referring to agreements made by the recipient amounts to an admission of the agreement. So the requirement seems to be more stringent in criminal cases, where the courts are expected to be more careful. In a case where the accused was charged with incitement to racial hatred by aiding the publication of a comic which contained racially offensive matter, the prosecution adduced evidence of the accused referring to the comic as your idea and your work, and an unfinished reply in his typewriter which made no mention of the comic. The Court of Appeal doubted whether the letters had properly been admitted. In a civil case, such doubt would not have arisen as need to reply would be overwhelming. Okay, so that's it. When you keep silent, we see that um, it could amount to a confession, and in the case where you don't reply to written allegations contained in a letter addressed to you, that could also amount to a confession. So moving on, vicarious confessions. Can a confession arise from the words or conduct of an agent? The position is as stated above, that a confession by an agent can only arise where it is made on the principles express or implied authority. So it's the same thing we saw when we discussed admissions, where we said where your lawyer as your agent, okay, who's representing you, admits to something, that will be admitted as an admission or as evidence. Or where in the case of what was the other one? The other scenario, there was the lawyer and I can't remember it now. Yeah, but where there's an advocate and client relationship, and the advocate was acting under your instructions, okay, and if they were admitting something, if they were saying statement or words, okay, which amount to confessions that would be admitted. I don't remember the other scenario of agency, but I think it's somewhere there, okay? So just like we have vicarious admissions, we also have vicarious confessions, where your lawyer who's acting under your instructions can confess, okay, on your behalf. So by an agent can only arise where it is made on the principles express or implied authority. And we discussed, okay, that an advocate's clerk has no relationship with the, with the client, okay? He's not, uh, he's not under any instructions from the client, and so whatever the clerk says, all right, cannot be taken to amount to an admission or a confession. All right, so that was the case of Evans, 1981, where it was held that a clerk's conversations with witnesses did not amount to admissions or confessions. Now, admissibility of confessions. Under Section 25A of the Evidence Act of Kenya, Subsection 1, a confession or any admission of a fact tending to the proof of guilt made by an accused person is not admissible and shall not be proved as against such person unless it is made in court before a judge, before a magistrate, or before a police officer other than the investigating officer, being an officer not below the rank of Chief Inspector of Police, and a third party of the person's choice. So we already see here that the conditions which must be present when a confession is being received, for it to be admissible in court, it has to satisfy the following conditions. Number one, it must be made in court before a judge or a magistrate, and if it is out of court, it has to be made before a police officer who is not the investigative officer. He should also be an officer of a rank of Chief Inspector of Police and above. And there should also be present a third party of the person's choice, so that there is a whole atmosphere of voluntariness, friendliness, and no intimidation whatsoever. There should be no intimidation or undue influence. And I think these conditions are here because a confession is very serious. And I believe personally that if somebody confesses, that confession can be enough to convict them. So it's important that these confessions are made or received in very strict and very serious environment, where we have somebody like a judge or a magistrate or somebody of a very high rank, a police officer, chief inspector of police or above. We don't want any mistakes. We don't want anything to be wrong. That is why we have these rules. And a third party of the person's choice needs to be present, because that third person can attest to the conditions, obviously, where the confession is received. Moving on, subsection 2 says the Attorney General shall, in consultation with the Law Society of Kenya and the Kenya National Commission on Human Rights, make rules governing the making of a confession in all instances where the confession is not made in court. And we already have these rules. They are called the evidence rules, evidence out of court confession rules of 2009. Excuse me. Alright, so in Kenya, confessions are generally not admissible unless made in court. However, out-of-court confessions are admissible under the Evidence Out-of-Court Confession Rules of 2009. Alright, so let's look at these rules, what they're all about. I believe it's a very small thing. We can go through it quickly. So let's just go through it. The evidence out of court confession rules. These rules may be cited as the evidence out of court confession rules of 2009. Interpretation, we have a section where the words or terms used in the rules have been interpreted, such as electronic recording media includes any removable or physical audio recording medium, okay? And recording officer means a police officer other than the investigative officer who is either a chief inspector of police or above, okay? Availability of rules. These rules shall be readily availed by the Attorney General for reference by police officers, accused persons, and members of the public, and shall be displayed at every police station and police unit. So these rules should be made available in every police post, okay? Every police uh, every police station should have these rules prominently displayed. They, upon request, they should also be made available to the accused person. Okay, the police officer should have a copy available to the to be given to the accused. All right, so we move on. Rights of an accused, that's section 4, rights of accused person. Where an accused person intimates to the police that he wishes to make a confession, the recording officer shall take charge of the accused person and shall ensure that the accused person does the following things. Number one, the police officer will make sure that the accused person has stated his preferred language of communication. So the first thing will be to ask the accused in which language he wishes to make the confession, mostly English or Kiswahili. Is provided. Number two, he'll make sure the accused is provided with an interpreter free of charge where he does not speak either Kiswahili or English. So where he doesn't speak either of those two languages, which are the common languages in Kenya, he will have an interpreter, okay, beside him, who will be interpreting. Number three, the officer will make sure the accused is not subjected to any form of coercion, duress, threat, torture, or any other form of cruel, inhuman, or degrading treatment or punishment. So unlike the common picture that is painted when in the movies and TV shows, where somebody is tortured in order to tell the truth, it's to confess to the crimes. Yeah, that is not how it should be done. So there should be no torture, there should be no force of any kind, and no manipulation or duress or influence. Okay, number four, the officer will make sure the accused is informed of his right to have legal representation of his own choice. So you can have your lawyer present when you are giving a confession. Also, the police officer will make sure the accused is not denied food or water or sleep. If you don't sleep, sometimes your mind doesn't work, okay? So, and it's also a form of torture to deprive someone of sleep. So food, water, and sleep must be provided, and the officer will make sure that the accused has his time, has his duration, including date and time of arrest and detention in police custody, established and recorded. All right. So the officer will record, okay, the accused person's uh, time and date of arrest, when he was arrested, and the duration he was in police custody. Also, the police officer will make sure the accused has his medical complaint, if any, adequately addressed. If the accused is complaining of a fever or pain or anything, okay, the officer has to make sure that is taken care of. And also the officer has to ensure that the accused is availed appropriate communication facilities. I don't know what this means, but if he wants his phone call, to talk, or call his lawyer or someone, to be present, then that will be availed to him. And lastly, the officer has to make sure the accused communicates with the third party nominated by him prior to the caution to be recorded under Rule 5. So he has to make sure that the accused person can talk with his uh, with his nominated person whom he wants to be present when he is giving the confession. Alright, moving on. The recording officer shall not record a confession from any accused person, okay, who complains to him of being a victim of torture or whose physical appearance shows signs of torture. So once a police officer, once the recording officer observes signs of torture on the accused person, he should refrain from taking the confession. So he should refrain from taking confession from such a person. And subsection 3, the recording officer shall ask the accused person to nominate a third party who shall be present during the duration of the confession session. And upon the appearance of the third party, the recording officer shall record the third party's particulars and relationship to the accused. So we said this, that one of the main things that should be there under Section 25 of the Evidence Act is the fact that the accused has a right to call a third person of his choice to be there with him, beside him, okay, when he is giving the confession. And the recording officer will record the relationship of that person has with the accused, and the names and ID of that person, and whatever else is needed. Now, Section 5 of the rules says, caution to the accused person. Subsection 1. The recording officer shall caution the accused person in the following terms and shall record his response. In court, do you wish to say anything? You are not obliged to say anything unless you wish to do so, but whatever you say will be taken down in writing and may be given in evidence. So this is this is where the accused is cautioned, all right, that whatever he will say will be used against them, okay, can be used against them. So they have a choice to give their confession or not. And this also tells me that even if an accused person were to say he wants to say something, then changes his mind before he says it, I believe this statement of caution would grant them that chance to change their mind and just walk away. Number 2, subsection 2, while recording the confession, the recording officer shall ensure and record compliance, that where the confession session is prolonged, the session included rest and relaxation period, okay? So if the confession is like a whole storybook, for example, and the yeah, the recording officer will make sure there are pauses in between and rest. Okay, yeah. So okay, subsection 3. The recording officer shall ensure that the confession is recorded at the same time it is made, okay, and shall record the date and time of commencement of the confession session and the place where the confession is recorded. So the confessions, if received or when received, must be recorded immediately. Okay, immediately. Of course, that is because you may forget certain things. Okay, if you are to wait. Mm. So it is recorded simultaneously while the person is narrating. The officer records it. Okay, and shall have the date and time of the confession and where it is being recorded. Okay. Now, section 6, electronic recording media. Subject to paragraph 2, the recording officer may record the confession of an accused person on electronic recording media. Where the recording officer records the confession of an accused person on the electronic recording media, first, the accused person shall be notified of such recording and of his right to say no, and the notification and any response by the accused person, preferably on electronic media. Okay, so and the recording shall be in the open. So where an accused person is being recorded, their confession is being received electronically via a what? Yes, via maybe a camera. If you want a camera, yes, a camera or a video recorder or an audio recorder, that person, the accused person will be told of the same. Okay, we are recording you right now. Do you want? You have a right to say no, I don't want to be recorded. Okay, all right. And the recording will not be hidden. So you cannot. Okay, I'm laughing because we have instances where people in the movies where uh, people walk in with wires hidden in their jackets or pockets, and just walk into and induce someone to confess or say things, right, or admit to their guilt. But really, if we have all these rules right here, how is that even realistic? How is that even possible? You know? So the recording shall be in the open. That person will see that audio device, recording device or that camera. It will not be hidden somewhere. Now, in the event of failure of the electronic recording media, the recording officer may do the following: may choose to replace the equipment and record the failure upon the resumption of confession session, or record in waiting. Okay, so where the camera or shuts down, maybe mid-sentence, or just has malfunctions in any way, the officer will have to mention that in the subsequent recordings. The fact that in the previous recording it was interrupted because of some problem or technical issue. Now, subsection 4, upon electronic recording, the first recording, which shall be the master recording, shall be marked with a reference number and sealed in the accused person's presence, while a second recording will be used as a working copy by the prosecuting authority during the period of exercise of prosecutorial discretion. So we have this requirement that the first recording, which is the original version, will be sealed in front of the accused person, okay, and marked with a reference number. I think this rule, obviously, it's common sense to imagine that you need to protect the original copy and seal it in front of the accused, because so that he has faith that whatever he said is going to be preserved in its original state and nobody is going to interfere with the recording, okay? Now, subsection 5, the recording officer shall produce the master electronic record to the court and may be requested by the court to prove its authenticity. So, yeah, that will be under the Evidence Act on electronic evidence, admissibility of electronic evidence. It should fulfill all those conditions, okay? So it is the master copy, the first and original version that is presented to court, and the court can request to have its authenticity proven to the court. A copy of the recording shall be given to the accused person if he requests it, okay? So those are the rules on electronic recording, okay? Electronic recording of confessions. So we move to confessions that are recorded in writing. That is section 7 of the rules. Confession recorded in writing. Where the confession is to be recorded in writing, the recording officer shall inform the accused person of his option to write his own statement in his preferred language or to have the recording officer write it for him, okay? Now, section 8 of the rules, clarification of confessions by accused persons. At the conclusion of the recording, the accused person shall be offered the opportunity to clarify anything he has said and to add anything he may wish. Okay? Okay, section 9. Section 9, Certificate of Confession. The recording officer shall ensure that the written confession or electronic recording media contains the following certificate at the end of the confession in the original language of the accused person. In court, I have read the above statement and I have been told that I can correct, change, or add anything I wish. The statement is true. I have made it of my own free will. All right. So there should be a declaration here at the end of the confession showing that the accused understands the nature of the confession, that he has revised it, that he has been told he can change or add anything, and he has to affirm the trueness of the statement he has made, and the fact that he has made it with his own free will. Okay. Section 10, confession not recorded in English or Kiswahili. In the case of a confession not recorded in English or Kiswahili, the recording officer shall ensure that it is translated into English or Kiswahili. Section 11, safety of recorded confession. The master recording or the signed confession statement shall be kept securely and their movements accounted for on the same basis as material which may be used for evidential purposes, as further elaborated in the force standing orders issued under Section 5 of the Police Act. So we are seeing that it is going to be treated as any item of evidence to be produced in court. So it will be treated with the same caution and the same, what do you call, seriousness. Now, Section 12, accused person arrested outside Kenya. Where an accused person is arrested outside of the geographical boundaries of Kenya for the purpose of being arraigned in a Kenyan court, and prior to arrival in Kenya, the accused person chooses to record a confession. Number one, the arresting authority shall record the confession if the governing procedures for obtaining of confessions in the arresting jurisdiction are in substantial compliance with these rules. Okay. Number two, the trial court shall be the final determining judicial body to adjudicate on the admissibility of confession so obtained. So confessions made in other jurisdictions by a Kenyan who is to be or by somebody who is to be arraigned in a Kenyan court. Those confessions can be received or recorded if the rules in that country are the same as the rules here, okay, in Kenya. And the trial court in Kenya is the final determining authority on whether the confession is admissible or not. Section 13, the recording officer, having informed himself of Section 26 of the Act, shall be the proper prosecution witness to prove to the court beyond reasonable doubt that the rules were complied with. So the one who is recording a confession will testify in court as a witness to prove that the rules, the out of court confession rules have been complied with. Okay, now section 14, certification by recording officer. The recording officer shall certify in writing that a confession was not obtained as a result of any inducement, threat, or promise having reference to the charge against the accused person. So it's not only the accused who certifies uh, below the statement, the confession, that he has given it free of any threats or inducements. Yeah, it is also the recording officer who will also certify that the confession was not received as a result of any threat. Now, section 15 and the final section of the rules, language of publication. These rules shall be translated and published in Kiswahili in addition to the official copy published in English, because the majority of the Kenyan population speaks Kiswahili. It's the national language of Kenya. So that is it on the confessions. All right. So that is the rules, the confession, out of court confession rules, all right? So you can see everything is provided for and it is strict just so it can preserve the sanctity of the confessions, okay? So that the confessions are not distorted or extorted out of the accused. All right, I'm going to stop there today. We will continue. We will continue this. We haven't finished this topic, so we'll continue it later. Bye.